In the year 1386, in France, a pig was arrested for murder. She had a defense lawyer. She lost. I need you to sit with that for a second, because I am not exaggerating for effect. An actual court, with actual judges, formally charged a pig with a capital crime, assigned it real lawyers, held a real trial, reached a verdict, and marched it into the town square, dressed in human clothes before it was executed. And this was not one bizarre one-off. For roughly 500 years, courts across Europe did this. To pigs, to rats, to a rooster. We're covering the single strangest trial this show has ever touched, the sow of Falaise. First, you need to understand how medieval Falaise actually worked, because none of this makes sense otherwise. Pigs didn't live in pens. They ran loose through the streets all day, every day, eating the town's garbage, which made them, essentially, unpaid sanitation workers with tusks. Everybody accepted the arrangement. Nobody thought too hard about a 200-pound animal wandering freely past open doorways and market stalls, right past infants left in their cribs while parents worked. In January of 1386, that arrangement finally went wrong. According to the surviving record, a 3-year-old sow got to the infant son of a man named Jonnet Le Macon, a baby about 3 months old, in his crib, and the injuries were fatal. Falaise did not treat it as a tragic accident. Officials had the sow arrested and jailed, the same as any human suspect, to await trial. Here's the detail that tells you how seriously they actually took this. A surviving receipt shows the jail charged the exact same daily boarding rate for the pig as it did for a human prisoner. Same cell block. Same bill. A murder suspect who happened to be a pig, on the same ledger as everyone else awaiting trial. Now here's the question that should actually be bothering you. Why put a pig on trial at all? Why not just deal with the problem and move on? It turns out this wasn't superstition or theater. There was a real, coherent legal theory underneath it. And once you hear it, it's almost logical. Almost. Medieval law split animals into 2 completely different legal categories. Wild pests, locusts, rats, weevils, the things you obviously can't put in a jail cell, got handled by church courts through formal excommunication. You'd read a legal summons to a field of locusts, and if they didn't leave, the church cursed them. But domestic animals, pigs, cows, horses, dogs, the ones that actually lived among people, fell under ordinary secular criminal law. Same courts. Same procedure. Same rights as a human defendant, including a defense lawyer, because a trial without one wasn't considered valid. In the Falaise case specifically, the record shows lawyers arguing on both sides. A prosecutor built the case against the sow, and a defense advocate argued for her. The verdict: guilty. The sentence: mutilation, then hanging in the public square. And here's the detail people always assume must be exaggerated, but it's well documented. She was led out dressed in a man's clothes for the execution, not for comfort. For symbolism, dress the condemned like a person, and the lesson lands. The law applies the same way to everyone, no exceptions, even if you're a pig. A local artist even painted the whole scene in fresco on the west wall of the town church, as a permanent moral lesson for Falaise. That mural hung there for over 400 years. Then, in 1820, a workman repainting the wall simply whitewashed straight over it. No ceremony, no debate. 4 centuries of infamous pig execution art, gone because a man had a job to do and a bucket of paint. And here's the part that still bugs actual historians today. Was this really about punishing the pig? Or was the pig standing trial for somebody else? Because look at who else was usually standing in that yard: the owner. the human being who let a 200-pound animal roam loose near a baby. Under the law of the time, you mostly could not hold an owner criminally liable for what his animal did on its own. There was no legal slot for the person who was actually negligent here. So the system used the only slot it had. And courts could get genuinely strange working out exactly where blame stopped. In 1457, in the French village of Savigny, a sow and her 6 piglets were all charged together over the death of a 5-year-old child. The court convicted the mother. The piglets walked. The record says there wasn't solid proof they'd actually taken part, and, generously, that they were too young to understand what they were doing. Which means, in the eyes of a 15th-century French court, a litter of baby pigs had an actual legal defense available to them that their own mother didn't. And Falaise and Savigny were not outliers. A historian named E.P. Evans spent years digging through European court archives and documented roughly 200 of these trials, spanning something like 5 centuries. In Basel, Switzerland, in 1474, a rooster was put on trial for laying an egg, because people genuinely believed a rooster's egg could hatch a basilisk, a creature that kills with a glance. The prosecutor argued the rooster was no ordinary bird, but a minion of Satan. The defense argued it was just an odd, natural occurrence, hardly the rooster's fault. The rooster lost and was burned at the stake, egg included. And in 1487, in Autun, France, a lawyer named Bartholomew Chassigny was assigned to defend a population of rats accused of destroying the region's barley crop. First move, he argued, the single summons posted at one church wasn't proper notice for rats scattered across the whole countryside. The judge agreed and ordered a second summons read from every pulpit in the region. The rats still didn't show, so Chassigny argued, completely straight-faced, that his clients couldn't safely travel to court because the roads ran through territory controlled by cats, their natural enemies, and no one could reasonably expect them to risk their lives to attend. The judge bought it. The case was delayed indefinitely and never resolved. The rats were, technically, never convicted of anything. Chassigny, for what it's worth, went on to become the highest judicial officer in the entire region. Laugh if you want. I certainly did, writing this one. But strip away the little coat and the gallows, and there's an actual legal question buried in here that we still haven't fully solved. Because the real question Falaise was wrestling with was this: when something that isn't a full legal person causes real harm, who does the law actually put in the dock? We never really answered that. We just changed the defendant. Plenty of places today still have dangerous dog laws where, after a formal bite hearing, a court orders the animal itself destroyed. Same basic proceeding, tidier paperwork. Corporations get treated as legal persons that can plead guilty and pay a fine, standing in for the actual humans who made the decisions inside the building. And right now, courts are starting to ask the exact same question about self-driving cars and algorithms, when the thing that caused the harm isn't a moral agent, who actually stands trial. 700 years later, we're still doing what Falaise did. We just took the little coat off. So that's the sow of Falaise. A pig with a lawyer, a courtroom, and a 400-year-old fresco that one guy accidentally painted over. And underneath the absurdity, a real legal question about blame that courts are still fighting over today, just with better-dressed defendants. Quick note, because I have to. This is legal history and commentary for educational purposes. It is not legal advice, and I am very much not your attorney, pig or otherwise. If you liked this one, tell me which case to break down next. Until then, watch where you leave the crib.